If you've been following the intersection of, consumer finance and the legal world, we have to talk about consumer litigation
Oh,
funding.
absolutely.
This industry has, it's just exploded over the last decade.
Right.
And frankly, until pretty recently, it felt like the regulatory Wild West.
It really did.
For those of you who might be just catching up, here's the core idea. Litigation funding is a way for a consumer with a pending legal claim, maybe a personal injury case, to get immediate cash.
Right. Cash now.
Exactly. In exchange for that money, they assign the funding company a slice of their potential future settlement or, a court judgment.
A piece of the pie, so to speak.
Our mission today is to cut straight to the knowledge around New York's massive attempt to rein this all in. We're doing a deep dive into Senate Bill 1104A, the Consumer Litigation Funding Act. And this isn't just, tweaking old laws. This is a whole new structure.
It is a brand new structure. And if you look at the legislative intent, it is laser focused on consumer protection. I mean, this act sets up state regulation, it mandates incredibly strict disclosures, and crucially, it puts firm limits on the charges these companies can levy.
So it's a complete overhaul.
It's a complete overhaul. It introduces an entirely new section, Article 39H, into New York's general business law. It covers everything from, basic definitions all the way to severe penalties for violations. It's arguably the most detailed regulatory attempt in the country for this sector.
Okay, so let's unpack this right away. Let's start with the definitions
Yeah.
because the legal mechanism here seems like the single most important piece.
It is.
The law explicitly defines this transaction as non-recourse.
That distinction is absolutely critical. Think of it this way. With a standard loan, if you, say, lose your job and can't pay the bank back, you still owe the money.
Sure, of course.
But in a non-recourse transaction, if the consumer loses their case and there's no settlement, no award, nothing, they owe the funding company zero.
Wow. So the risk is entirely on the funding company.
Entirely.
Right.
Which is, historically why they've charged such high rates. It's an assignment of a potential asset. It's not a debt.
That really helps clarify why regulating it is so complex. It isn't a traditional loan. So let's talk about scope. Who exactly does this law apply to?
Okay, so it applies to the consumer, which is defined as a natural person living in New York with a pending bona fide civil claim.
Right.
And it applies to the company, which is any entity entering into a funding contract with that consumer. But, and this is a vital boundary, the contract can be for no more than $500,000.
Okay, why that cap? Is that meant to carve out, say, the huge, complex commercial litigation funding for big businesses?
Precisely. It keeps the law centered squarely on true consumer protection. If you're funding a multi-million-dollar corporate lawsuit, you are not the target of this regulatory effort.
Got it. And we also need to define the money itself very clearly. The funded amount is the easy part. That's the cash the consumer gets.
Right.
But the law seems very, very broad in how it defines charges.
Yes, and that's intentional. The definition of charges is incredibly comprehensive. It includes all administrative fees, origination fees, underwriting, interest. It doesn't matter what the company decides to call them.
So they can't hide costs.
They cannot hide costs.
So if a company tried to call a high fee, I don't know, a document processing fee or something, it all just counts toward that final rate in the cap.
That is exactly the point. It's meant to close every loophole for disguising the true cost of the money.
Now, what's fascinating here is who the law specifically excludes from being regulated as a company.
Right. This clarifies who the law is really targeting. So if an immediate family member gives the consumer money, that's exempt.
Makes sense.
Large banks or lenders that just provide the capital to the funding company, they're also exempt. The law is focused on that direct interface with the consumer. And, logically, attorneys or accountants providing their professional services aren't considered funding companies either.
Okay, here's where it gets really interesting for me. The mandatory consumer safeguards. These are built right into the contract rules to make sure the consumer knows exactly what they're signing.
Transparency is the goal, but the rules are highly prescriptive. Contracts have to be in clear, coherent language, using, common, everyday words.
So no legalese.
The statute literally says the language should enable the average consumer to understand it without a lawyer. That's a massive shift away from dense financial documents.
And it's not just the language. They're almost micromanaging the transparency.
Oh, they are. The contracts must be fully filled in when they're presented, and they require the consumer's initials on every single page.
Every page.
It forces the consumer to acknowledge the gravity of the whole document, not just sign the last line.
But I think the single strongest consumer protection has to be the cooling off period. You get a mandatory 10-day right of rescission,
And it has to be in 12-point bold type font, right, on the contract.
so you can just cancel it.
You can void the whole contract without penalty, no further obligation, just by returning the full amount within 10 business days.
That 10-day window is huge.
It is. In these high-pressure situations, someone might sign out of pure desperation. This gives them time to talk to their family, talk to their lawyer, and really weigh the decision, knowing they can walk away clean.
And what about prepayment? You mentioned that too.
Right. There are absolutely no prepayment penalties. Any fee for paying it back early is explicitly unenforceable.
So that prevents the company from locking you into costs calculated over 5 years if your case settles in just 6 months.
Correct. Now, let's get into the core financial mechanism, the dual limitation on costs. This is where the law gets really novel.
Okay.
First, the repayment structure is mandated to be a predetermined amount based on intervals of time. It cannot be a percentage of the recovery.
So they set a schedule of charges that build up, say, every 180 days the funding is out there. That sounds cleaner, but why time-based?
It creates clarity for the consumer. They can see exactly what they'll owe based on how long the case takes. But here's the major constraint, the second overarching rule. The maximum allowable charges are capped at 25% of the gross proceeds from the legal claim. And that cap applies no matter what the time-based charge calculates out to be.
Wait, hold on. So the company has to charge based on time, but if the final settlement is small, the total money they get back, including their principal and all those charges, can't be more than a quarter of what the client actually won.
Exactly right. It forces funders to model their time-based charges very conservatively. They have to assume that even if a case drags on for years, if the final recovery is low, the funder takes a significant haircut to make sure the consumer gets the majority of their award.
Wow, that's a highly protective, if pretty complicated, structure.
It is, which makes the mandated disclosures even more important. The contract has to spell out, right on the front page, the funded amount, all the one-time charges, the maximum total amount assigned, and a complete payment schedule.
A payment schedule broken down by, what was it?
Every 180-day period. It shows the consumer exactly how the cost grows over time, forcing a really clear understanding of the time value of this money.
Okay, moving on. The law seems to place really stringent requirements on the relationship between the company, the attorney, and the consumer. It's all about ethical boundaries.
Absolutely. The attorney essentially acts as a mandatory gatekeeper.
How so?
The consumer's lawyer has to sign a written acknowledgement attesting to 6 specific points that separate this financial transaction from the legal strategy.
And these attestations are very specific. The lawyer has to confirm they reviewed the disclosures with the client, that they're being paid on contingency.
And critically, they have to confirm that the entire recovery will be dispersed through their regulated trust account.
Right. And what about conflicts of interest?
2 key points there. The attorney must state they haven't received and will not receive any referral fees from the funding company. And they must attest that they provided no financial, tax, or benefit planning advice about this specific funding deal.
That distinction ensures the lawyer's loyalty stays 100% focused on the legal outcome, not on selling a financial product.
And you have to note the nuclear option here. If the attorney fails to complete that acknowledgement about fund disbursement through a trust account, the contract is immediately null and void.
The whole deal is off.
The whole deal is off. The company loses its right to recovery. It shows you just how serious the state is about regulating the flow of money.
And if we connect this to the bigger picture, the law also strictly prohibits the company from paying referral fees
Right.
to anyone involved, right?
Right. And not just to attorneys, but also to medical providers, chiropractors, physical therapists. It's aimed at stopping that closed loop of referrals, where a funder pays for the case, sends the client to a specific doctor who then gets paid back.
It prevents the funding company from becoming a silent, influential partner in the consumer's whole recovery process.
Exactly. Which brings us to the biggest question. Control. Does the funding company get any say in how the lawsuit proceeds?
I would assume not.
Absolutely not. The law is crystal clear. The funding company gets zero right to make decisions about the legal claim or a settlement. That power stays solely with the consumer and their attorney. The funder is just a passive investor in the outcome.
So they can't pressure someone into a bad settlement just to get their money back faster.
Correct. And to protect the actual legal strategy, all communication between the consumer's attorney and the funding company is protected under attorney-client privilege and the work product doctrine.
Okay, hold on. For our listener who might not deal with legal jargon every day, what does work product doctrine mean in simple terms here?
Good question. It simply protects the lawyer's strategy, their notes, their research, their private thoughts about the case. It means that just by getting funding, the consumer isn't accidentally giving the funding company a window into their lawyer's secret playbook.
You'd need written consent for that.
Express written consent, yes.
So with this really aggressive regulatory scheme, what does it mean for the companies that actually want to operate in New York?
Well, they have to register and submit to oversight. They must register with the New York Secretary of State, the SOS, before doing any business.
And there are fees, I assume?
An initial fee of $500, a renewal every 2 years. And crucially, the SOS is empowered to evaluate the applicant's character and fitness, almost like a professional licensing board.
And I saw something about a bond.
Yes, accountability is enforced through collateral. The SOS can require a bond or letter of credit up to $50,000 to help guarantee they follow the rules.
And they have to file all their contracts with the state first.
Exactly. Transparency is front-loaded. This ensures compliance before a contract ever reaches a consumer.
It is worth mentioning that deals made before this law took effect are exempt, right? There's a grandfathering clause.
A crucial provision, yes. It ensures the changes only affect new business, not existing agreements.
What about ongoing transparency?
The law mandates annual reporting. By January 31st each year, companies have to report the number of fundings they did, the total dollar amount funded, and the annual percentage they charged on cases that were paid back.
And the state doesn't just sit on that data.
No, the SOS has to make this information public within 90 days, though they keep company and consumer names confidential, of course. It creates market-wide oversight.
Okay, finally, we have to talk about the penalties, because they seem severe.
They are. If a company willfully violates any part of the act in a specific case, they face a dual punishment. First, they waive their right to recover both the funded amount and all the charges.
They lose their entire investment.
Their entire investment. Second, they're liable for a civil penalty of up to $5,000 per violation, which goes to the state.
That's an incredibly strong deterrent. If you break the rules, you don't just get a fine, you lose your principal. That should ensure compliance from day one.
It should.
One last technical point for you to know. Lien priority. When the case settles, who gets paid first?
Lien priority is just the order of payments. Under this law, only the attorney's lien, the lawyer's fee, and certain statutory liens like Medicare take priority over the funding company. So the funder is next in line, before almost any other creditor the consumer might have.
So zooming back out, this act really redefines the whole relationship. It establishes transparency, it mandates disclosures, it creates real safeguards like that 10-day cooling-off period, and it imposes those concrete cost limitations.
And the ethical wall.
And the rigorous ethical walls. It moves the industry from just general contract law into this highly specialized, highly regulated consumer finance niche.
And that highly specialized framework is what leads us to, I think, the most complex question about the future of this market.
Okay.
The legislation requires repayment to be based on time intervals, right? Calculating risk over duration. Yet, at the same time, it caps total charges at 25% of the final gross proceeds.
Which could be anything.
It could be anything. So this creates a constant tension. How will funding companies structure those time-based charges, which naturally grow the longer a case lasts, to navigate the very real risk that a small settlement will trigger that 25% cap and force them to forfeit years of accrued charges? It raises a big question. Will this rigid dual regulatory structure ultimately lead to more, or will it lead to fewer funding options being available for the very consumers it aims to protect? And that's something for you to explore as this market adapts.
Food for thought indeed. That's all the time we have for this deep dive. Thank you for joining us. We'll see you next time.